The next argument is in re adoption of CM, a minor, appeal of BM mother and DM and PM maternal grandparents. Representing BM mother is Mr. Craig Bluestein. Representing CM is Miss Mary Coyne Pugh. Representing JC is Miss Chelsea A. Christensen.
Good afternoon. This case pertains to a proposed adoption of a minor child. The mother and maternal grandparents have raised the child since birth, and the father filed a custody complaint following a lengthy period of his absence. The maternal grandparents filed a petition for involuntary termination of the father's parental rights, which the mother joined. The mother voluntarily relinquished her own parental rights to free the child for adoption by her parents, maternal grandparents. The Orphans Court granted the petition and entered an order terminating the father's parental rights. The Superior Court reversed, finding that this court's decision in the adoption of MRD precluded the termination of the father's parental rights, as the contemplated adoption would not create a new family unit. This court granted allowance of appeal to examine whether the Superior Court erred in applying this court's holding in re MRD under the facts of this case, and whether the reversal constituted an improper disturbance of the factual and credibility findings of the trial Orphans Court. As that is a fair encapsulation of the case, Mr. Bluestein, feel free to introduce yourself and begin.
Thank you very much, Mr. Chief Justice. Justices, may it please the court, I have the privilege of representing BM, the mother, in this case. The issues were correctly recited by you, Chief Justice. We all know what the MRD case held. Here, in this case, this is not an MRD case. This case does not involve Section 2101 or 2901 or 2903 of the Adoption Act. Here, mother was requesting to relinquish her parental rights, unlike the mother in MRD. Here, the grandparents were adopting. Here, the grandparents are a married couple. They're horizontal as to each other. They are married and would raise the child whom they would adopt, and they would both be vertical relationship with the child. Some concerns that were raised in MRD. These concerns are not present in this case. The dissent in the Superior Court decision was correct. Judge Pellegrini is determined in his dissenting opinion that the majority based its view of the case on what it perceived or discerned to be the public policy behind the strict language of the Adoption Act, and ignored the language, the mandatory language of the Adoption Act. Judge Pellegrini also found that the Superior Court ignored the findings and the credibility determinations and the findings of fact of the trial court, which Judge Pellegrini felt was improper, that the findings of fact, which were supported by the record, had to be accepted by the Superior Court as found by the trial court, and the Superior Court did not do that. This adoption was not pretextual, as the Superior Court majority suggested. In fact, that majority said on page 10 in footnote 7, and I quote, "Notwithstanding the learned dissent's characterization of our rationale, we do not find that the proposed adoption is pretextual." This honorable court also in MRD at page 1126 of the A3rd version said, "If mother had desired to relinquish her parental rights to the children, and assuming arguendo that an adoption by grandfather and the termination of father's parental rights were in the children's best interest, grandfather would be permitted to adopt the children, and termination of the father's parental rights would have been proper, ending our inquiry."
Counsel, could I ask a question, please? I think we've given you more than your allotted 2-minute question-free zone. What was going to change here? The testimony which the Superior Court relied upon included maternal grandfather's testimony that he didn't anticipate there to be any change, and that mother would remain in the mothering role unless she became incapacitated. Where's the new family unit? Where's the change? Why wasn't the Superior Court entitled to find under these circumstances this was an instance of the custody, the TPR laws doing the work that the custody laws are supposed to do?
Thank you for the question. There are many answers to it. I would refer you back to about 50 years ago, the case of B.E. decided by this Honorable Supreme Court, which determined in a case where there was no adoptive parent proposed, and which case was cited by the Superior Court and father in this particular case, the B.E. court said that the termination of rights and the legalization of the adoption creates the new family unit. Indeed, there are at least 16 reasons, which I cited in my brief, which create the new family unit. The next day, mother could be removed from the house if her parents didn't want her to live there. The mother may move out whenever she wants to. The mother has no duty to take care of the child. Also, with regard to gamemanship, there are probably 20, 30, 40% of all termination of rights cases across Pennsylvania where a few years go by, there's abandonment by one parent, that parent suddenly files for custody, termination of rights is filed for, and the case is heard on the termination of parental rights case. That is before the court. The Superior Court, with all due respect, may not decide for litigants to what forum to go. Grandparents, in this case, grandparents and other are permitted to go to orphans court to file for termination and adoption if they choose. They're permitted to go to custody court if they choose to. And by the way, with regard to what Superior Court said about why didn't they just go to custody court? Well, I would suspect that father in this particular case would have been the first one to argue they have no standing in custody court, because father would have argued mother is raising the child to that point in time.
Does anybody dispute that maternal grandparents were or would have satisfied in loco parentis?
It's very questionable at that time whether they would have satisfied in loco parentis. Father's counsel probably would have argued they lacked in loco parentis because mother's right there with the child.
Well, that's interesting because they sure set it up differently as adoptive parents. I mean, circumstantially, wasn't the Superior Court entitled to look at the fact that it wasn't until father filed for custody that mother and her parents went for this TPR option? Isn't that exactly the weaponization that we warned against in MRD? Doesn't this case look, one last caveat, doesn't this case look a lot like an attempt to get around MRD by having the additional slice of fact that mother goes in and agrees to relinquish?
Well, that's a very fair question, a question that was brought up by father at the trial court level. As you know, Judge Murphy, well respected across the Commonwealth, considered father's claim that this was quote unquote contrived. And she addressed herself to that. She heard testimony, and it's on the record, which supports her decision that mother is ill, that it's a progressive illness, that it's life-threatening.
Counsel,
Often,
that particular issue interests me, if not intrigues me. It's fair to say that father raised a sufficiency argument regarding 2511A and B, both at trial and incorporated in his appeal, despite the fact Superior Court injected its own public policy arguments in it. So father's sufficiency issue is still preserved. So one of the questions I have, and embedded in the Ellicott grants, is the belief, as you said, the fundamental basis for a 2511A and B finding was that mother was ill, had lupus and scleroderma, but there was no medical evidence presented by your client whatsoever other than a statement that she had this condition. Share with me how a finding of clear and convincing could be found by that statement alone, and how that is not an abuse of discretion or an error of law on part of Judge Murphy.
She did testify at some length rather than just a statement about her lupus and sclerodoma. It's not a bare statement in the wind. She also, being a nursing student, had medical training. She talked about what the doctors have told her. There was a great deal more than just a mere statement. Her father also talked about her suffering that illness. Yes, there was no medical testimony, but the trial court was reasonable in relying upon it. And also, as we all know, the trial court got to watch the witnesses and observe their demeanor. The trial judge, Judge Murphy, found mother and her father to be credible and discredited the father not only on that, but on many points. But the trial court was certainly able and the one in a position to determine whether these facts were true.
All right, share with me this position then. The judge also found under 25A1. Now, I'm sure you're aware that that was amended back when, in 1992, to go from 6 months to immediately preceding the filing of the petition. So this petition was filed, but 2 months prior to the filing of the petitions, less than 2 months, father filed his petition for custody. How is it not an error of law to ignore the plain reading of the statute immediately prior to the filing, when in fact he did show some concern by filing?
In this case, like in all cases, what the abandoning parent does during the 6 months immediately preceding the filing of the petition is to be considered. She considered that. Clearly, the filing of a custody petition is one fact, but there's about 100 other facts that he didn't do. No cards, presents, letters, phone calls, etc., except for one in February. And she didn't mechanically apply the statute as is required. She went back 2.5 years and determined that given the entire picture, there was sufficient basis based on what he said, and in fact, largely on what he said, as you know, because he was called to the witness stand first. So much of the 2511A evidence came from his mouth, showing that he abandoned the child for the requisite 6 months and more, 2.5 years. So there was.
Counsel, Justice Donahue, along these same lines, and Justice Weck's earlier questioning, one of the trial court's statements, if not findings, was father waited too long to bring a custody proceeding. And when I read that, I thought to myself, why can't we look at the other flip side of that, which is mother waited too long to bring a termination of rights proceeding, thereby framing an issue as to whether or not this was the gamesmanship that we really attempt to avoid in these kinds of cases. Why was the father, why did he wait too long, but mother, who apparently, and I don't know precisely from the record, how long she suffered from this condition and the intensity of it is in the lack of medical testimony. I mean, it would appear that this had been a long-standing problem, and yet she waited until after the custody action was filed to relinquish her rights and to otherwise bring the termination petition.
Well, respectfully, Justice Donahue, the statute requires a trial judge to evaluate the conduct of the parent whose rights are sought to be terminated. So the trial judge did exactly what she was required to do, and his explanations for his absence and what post-abandonment conduct he engaged in. Taking your suggestion or question to further limits, what if mother waited 10 years and the father didn't see the child for 10 years, 12 years, 14 years, and he filed a custody petition yesterday, so she filed a TPR petition today because the child's well enmeshed in his or her life now, perhaps with grandparents, perhaps with a live-in partner of mother, perhaps with a husband of mother. This happens all the time in 20, 30, 40.
Should it? That's the question I think that we're asking is, should it? I mean, was not the custody court capable of dealing with the myriad of issues that are presented in this type of situation?
I think the trial court should not look at, to answer you directly, the length of time during which a petitioning parent waited to file a petition. The case is even more strong for termination when a father or mother is absent for 3 years, 5 years, 10 years. To say, well, you waited 10 years to file a termination petition would not make sense. We have 10 years of absence in my example. The more absence, the stronger the termination case.
But counsel, I'm sorry, go ahead,
Can I
Chief.
interrupt you? I'm sorry, Justice Docker, do you have a question?
No, go ahead, Chief. You go, then I'll go.
What you're saying, I could not disagree with more, and frankly, it frightens me. And I don't know if we have to use this case, whether we have to use our Rules Committee, or we have to go to the legislature, which we have the resources to do. But what you said earlier in your argument is that in a quarter or a third of the termination cases in Pennsylvania are pretextual and are actually about trying to eliminate a parent's custody. Now, is that what you perceive is going on in Pennsylvania?
Not at all. If it was interpreted that way, I did not mean it that way. I'm just saying that in many cases, one of the acts by a parent who's been absent during the 6 months immediately preceding the filing of the petition is a filing of a custody complaint.
That's not the point. The point is, we know here, you may get away with it, as the Pellegrini dissent said, but we know that this is a tactic to stop father from getting custody. Mm-hmm. Again, it may be permissible under the statutory scheme, but father made a good point in his brief. As a matter of equity, as a matter of unclean hands, can court do something if a month after you prevail in this case, the parties try to enter into an agreement to give mom custody so that they're right where they would have been if they won the custody case? Or assuming for a second, I don't know if mom knows this or you know this, but mom can't adopt this child without a partner. But if mom marries, God forbid she doesn't die, and she marries, and now parents say, grandparents say, well, there's no problem. We'll relinquish parental rights, and mom, you and your husband adopt. Now, that's what I think all of us are railing against, because father has a constitutional right to raise his child, and you've come up with a clever workaround to defeat that constitutional right. Now, could courts do anything about that? Could courts say to mom or grandparents, no, get out of here. This offends, you have unclean hands and it offends equity. You can't do this workaround. Or are we stuck that they can make the next maneuver as father portends?
No, courts can do something about it. And in real life, even in this particular case, I ascertained for myself whether that is what we're talking about here, and I satisfied me that that's not what we're talking about. But to answer you more directly, yes, the court, 3 years later, the trial level court, if the mother, for instance, goes to readopt the child, the trial court's in a very good position to evaluate what went on and how this request to adopt came about and whether it violates public policy, what went on here. So there is a trier of fact and an arbiter to look at that always.
At the exclusion of forbidding the child to develop a relationship with his father. The question I have for you is, and I find this very interesting, Justice Baer nailed my question, but the question I have for you is, you say this is not gamesmanship. They file in February, and he files in February, and she files termination in April or so. That being said, if the purpose and underlying reason was her medical condition, and I would strongly disagree with you that the record stands for anything other than her personal comments as a student, how is it not feasible that their relationship with the grandparents could not have been preserved, say, via custody court or even standby guardianship in a separate statute and act? Why would you cause the termination of a parental right, which, as we know in family law, is the capital punishment in custody?
People, and in this case, termination of parental rights was asked for because he engaged in conduct which satisfied the 2511A grounds, like in all cases in Pennsylvania. Yes, I agree that it is a possibility that grandparents could have preserved their rights through some sort of custody action, but I'm not sure because of the standing issue. With regard to the standby guardianship suggestion of the Superior Court, that makes little sense because, as we all know, a standby guardianship is a very temporary document. It lasts for 60 days, and it requires the consent of both the parents. Presumably, father may well not have consented to that, but it's only 60 days in length anyway, and it arises upon the occurrence of a triggering event. So that's a very temporary solution, 60 days.
Okay, so listening to your answer to Justice Dougherty prompts me to ask, was this primarily then motivated to just get rid of this annoying guy because you said something about his conduct was disturbing? So I guess his conduct was not sufficiently disturbing until he filed for custody, whereupon it occurred to mother, boy, I can't put up with him anymore. So get a TPR, and nothing changes in the custodial environment of child. Child is still with mom and her parents, but what is changed is dad has suffered the death penalty of custody. Why is this qualitatively different from MRD, and why should we allow this workaround to avoid the consequences of MRD?
This occurred because grandparents had a discussion with another attorney and decided they wanted to protect the future of this child as best they could because they were aware of what the past had been. They were also faced with knowing what losing a child is like because they lost one of their children. They wanted to make sure this grandchild of theirs was protected forever as long as they could help protect her and provide a good life. They perceived that this child was not going to have a good life and have a confusing life if she had to bounce back and forth between people, one of whom they perceived as not a safe person for her to be with. So they wanted to take steps to ensure her future. That's what it was about, in addition to the fact that their daughter, the child's mother, might not be around for the child's full minority to raise her. That's what the case was about. This raises serious implications, excuse me, for...
Saying again, it's Chief Justice Barrett. Doesn't it, again, as all my colleagues are saying, isn't it troubling as a matter of public policy that maternal grandparents now become parents? Mother now becomes her own child's sister. And again, if God forbid mother lives, and I've seen lots of civil cases when I was a trial court judge where somebody was on death's door when it was convenient for damages, and then somebody was going to live longer, and it never worked out that way. And so it's hard to, it's hard to evaluate, and of course the trial judge did it, mom's life expectancy, and we wish her well. But if mom lives, mom's a stranger to the child dies tragically with insurance, mom gets nothing, mom dies, child gets nothing. Again, unless this is all subterfuge and they use other legal documents to go through it. Grandparents die, mom and child each take half under the intestate code because they're sisters. Doesn't that bother you as a matter of public policy and what the legislature intended and what we're trying to accomplish?
I understand the point, and it raises mild concerns, but it doesn't trouble me to the point where the statute should be ignored in favor of a discerned public policy. This happens a lot in the foster care arena too, where a parent lives with her parents, but Office of Children and Youth won't let that child stay with mother, but they'll let the child stay with grandparents, although mother happens to be in the same house, so long as there's supervision. And they might even close the case if grandparents adopt, so they can be sure that the child is well taken care of legally and physically and emotionally in every way.
That's a dependency case.
Right. Yeah.
VR cases is baffling. VR cases is baffling to me. I mean, aren't there enough children in this Commonwealth who need the TPR that we've seen in trial courts many times, such that it shouldn't be diluted by these these weaponization of custody wars.
Well, it won't be diluted because those cases will stand on their own merit. And you have, and we have in this Commonwealth, MRD to protect against situations that present itself in MRD. But you also have at least one situation decided by Judge Lazarus and Dubot and Strasburger on December 1st, 2017, after MRD, where extremely similar facts were presented. Father's rights were terminated involuntarily. Mother consented. The child stayed with grandparents and was adopted by them. And those three judges felt and concluded that the fact that mother would have regular contact with the child should not prevent permanency for a child by preventing grandparents from adopting. Now, I'm not citing that case because it's unpublished, and I don't offer it for authoritative value, and I don't offer it as instructive, but just illustrative.
But you could argue it. You could argue it for all of those purposes, counsel. We could accept that argument. The difference is here, I think what we are focusing on is the custody proceeding that was commenced in this case. And I take you at, your full word and the grandparents' views that they were concerned for the child if the child spent time with the father. But their real concern was that the custody court wouldn't agree with them. That was the real concern, because if all of those things exist, and this was a bad man who was a bad father and would have been a very negative influence, the custody court would deal with that situation. Their concern was that the custody court wouldn't see it the way that they did. And I think that's the concern that we're all expressing here. Unlike the situation with your traditional foster care, you don't have a parent in those cases who is attempting to assert natural parental rights. In this case, we have a father who stepped up to the plate. And I think that for me anyway, and I think from what I'm hearing from my colleagues, that's what the rub is in this case. A custody court could have dealt with all of the issues that your clients were concerned about. But instead, it was more efficacious to just cut off the custody proceeding by terminating the father's rights.
Well, while one could perceive it that way, that's not the way the trial court saw it based on the testimony of everyone.
Didn't everyone admit that they didn't consider a termination proceeding until the custody action was filed? Isn't
essentially,
that part of the record in this case?
Essentially, they decided to do it after a custody case was filed. Yes.
Correct.
No question about that.
And
but I would say
conciliation counseling was ordered. They had to meet with a DRO or somebody. There was a support conference and all this stuff. And mom just essentially said, I don't want all this rigmarole. Let's go to plan B. I mean, custody litigation is unpleasant. It's cumbersome. It's expensive and stressful. So who can blame mom for detonating the nuclear option here? It sure got this guy out of her hair. Isn't that what happened?
No, the grandparents decided after hearing about the situation that they wanted to secure as best they could the future of the child. They weren't parties to the custody case. They had no involvement. They didn't ask that it be stayed. They just filed this. The custody case may have continued on. It just didn't. But they had no involvement with that case continuing on at all. They weren't parties to it. They requested nothing.
But the mother relinquished her parental rights. The mother relinquished her parental rights. The mother was a party to the custody proceeding. None of this would have happened unless the mother had relinquished her parental rights. So
I agree.
You can't focus on the grandparents in this case. The mother was full on involved with this Plan B, as Justice Weck referred to it.
The mother made a nuclear option that she was actually willing to no longer be this child's mother to protect this child in connection with grandparents' petition for termination and requested adoption. That was a huge thing to do. And you will find that very little as time moves on. And I don't think there's any floodgates we have to worry about people giving up their own rights in favor of their parents unless they can't raise a child. or they face some illness that they may not be around.
She's betting on the fact that she's going to die. I think we got this. I think with greatest respect to all of us, and it's certainly an emotional case and one that has all of our attention. If there's no additional questions, there's no reason to retread what we've covered with you. So I'd ask all my colleagues, does anybody have a question that you think has not been asked of Mr. Bluestein? All right, then, Mr. Bluestein, I'll give you a chance, since I sort of cut this off because I even if this was a court of one, I could go on with you for hours because of the nature of the case. So,
Yes.
I'll give you a chance if you want to, in a sentence or two, to complete anything you want to say, recognizing that we understand the case entirely, implicitly, and understand your argument, which you've articulated well.
Thank you. You said in the MRD, this court said in the MRD, that the inquiry would end if the statutory requirements were met. And if the mother relinquished her parental rights, that's exactly what happened here. In addition, a new family unit is being created by 48-year-old Supreme Court law as espoused in BE. That should end the inquiry, especially because the concerns you raised validly were addressed by the trial court, ruled in favor of the petitioning grandparents by the trial court. Credibility was given to them by the trial court. And unless we want to make appellate courts super fact finders, we're obliged to accept, if there's support in the record, the trial court findings. I would ask you to end the inquiry, to reverse what the Superior Court did, and to remand this for a pleasant final hearing by the grandparents where permanency can be achieved. Thank you, Your Honor.
I'm told that Ms. Pugh, well, nominally an appellee, actually wants to argue on behalf of the appellant. Is that correct?
Yes, Your Honor. May it please the court.
So,
My name is-
Ms. Pugh, let me just say this. It's a little bit unusual to be, it's not unheard of, it happens. Listed for appellee, argue for appellant. What I would ask you to do, you've heard all of this. We've explored every aspect of it, I think, with Ms. pretty carefully. If you have something you want to add, feel free to add it, but let's not retread this emotional ground again.
I certainly won't. And Mr. Bluestein actually had most of my argument, and you hit most, if not all, of the issues. The one thing I would like to just comment on is this was a long TPR case where the judge heard much evidence about what father did not do in performing any parental rights for this child. He filed custody when he was absent in her life for more than 2.5 years. And he did file for custody, and we cannot put too much emphasis on that one filing. When he didn't support her, he didn't reach out to her. He admitted he had no bond with her, and he admitted that he would not necessarily be able to identify her. So the totality of the circumstances, and the judge recognizes that, the birth father does not recognize that he faces the termination, not by custody gamemanship, but by his abandonment and his failure to do anything. And had he filed for custody at some time during that 2.5 years, we would be looking at a very different scenario. And I don't think we.
Question about the custody counsel. Are you aware of any barrier at all to the trial court having decided in the custody case that dad would have no custody time and no visitation? Are you aware of anything that would prevent 100% custody, 100% legal and physical custody for mother at the end of the day?
No, I'm not aware of any of those factors being presented at this time, because it was stayed, and it was stayed so that we wouldn't have conflicting rules of law.
All right, given your answer to my question, Mr. Bluestein, in his closing remarks, asked that we just send it back for what he called a, quote, pleasant, unquote, hearing. So I guess is part of your viewpoint as well that we should try to focus on pleasantry because custody litigation is inherently unpleasant?
No, I don't think we need to be pleasant. I think we have to look at each case and fact by fact and what parents did or didn't do in performing their parental duties. And custody is very different than parental rights. And the fact is that the Orphans Court looked at the totality of the circumstances, looked far more than 6 months, and saw that this father did nothing for this child, and yet he knew how to use a custody filing because he did it for 2 other children 6 years prior.
I'm sorry to interrupt you, Chief Justice Baer.
Interrupter.
I wanted to challenge you respectfully. First of all, I don't think there's any question on this record. I don't think that there's grounds to terminate father. So I don't know that you need to argue that. It's not the issue before us anyway. We obviously do an Alice Potter grant and address the issue. But you said, well, if he had filed earlier than 2.5 years, but we write to the law. We're not the trial court deciding this case. And that's not true. Under the legal construct before us, if he had filed for custody, that he could not perhaps have been terminated. But put that to a side. If he had filed for custody 3 months or 6 months in, as a matter of tactics, maternal grandparents and mom could have done the exact same thing. Perhaps you as child advocate would not be on the same side. But what they're asking is a decision from this court that permits that. Permits as a matter of tactics, if parent so foolish as to agree to terminate her rights, there can be a substitute set of parents. Isn't that correct?
No, I don't think so, Your Honor. I think that the custody filing was his attempt to become involved in this child's life, and that the custody factors are very different than termination.
You always have to be mindful of the age of the minor. This child's 3 years old, correct? How old's the
Right
child?
now, today 5.
5. So you keep referring to father's torturous history. In fact, father, what seems to be on this record, has overcome transitional housing, inpatient psychiatric hospitalization, as well as walking off some type of probation. That being said, is there not an element of reformation and redemption that should be provided to father at such an early stage in a child's life? From 3 years old, that father could have 15 additional years of proving himself to be a great dad. Or custody court could provide supervised visitations to see if he lives in the eyes of the court as to the torturous background that you allege, both of you allege, he had. So share with me.
Yes, Your Honor.
To the child, why is that not essential to the determination as to a termination right as opposed to a supervised therapeutic custody?
So with all due respect, Your Honor, I am very much in favor of all types of reformation in all forms. And I applaud all that can. But it's not the child whose childhood is suspended and has to wait for reformation and have to wait for parents to wake up and to decide to perform parental duties. We do know that children at tender ages is where their bonds form, and that is where they gain their nurturing and their stability and their permanency. And without
the child's bond with grandparents and mother would be lessened if the child developed an additional love and bond with father?
No, not necessarily. No, not necessarily. But what is father's role in this child's life? The child.
We'll never get to know if we rule in your favor, will we?
No, we do know that the child's her own best interests actually have a place in this, and that she is entitled to a safe and nurturing, permanent environment where she can predict that she is being taken care of.
No argument, and presumably our custody courts are well able to provide that. I think we're a little bit far afield. Any other questions for Ms. Pugh? All right, Ms. Pugh, anything you want to say in summation?
No, thank you. I think it's reflected all in my brief. Thank you, Your Honors.
Oh, you're welcome. Ms. Houston, I assume you're going to argue on behalf of father.
Yes, Your Honor.
Go right ahead.
Good afternoon, Chief Justice Baer and Justices of the Court. My name is Chelsea Christensen. I represent the appellee JC, father of CM. This matter presents another attempt by a parent to utilize the Adoption Act for improper custody gamesmanship in the absence of a proposed valid adoption. Over 2 years ago, father filed a custody action seeking to reunify with his daughter. The parties participated in 2 custody proceedings, several child support proceedings, and despite, or rather in light of this litigation, appellants decided it was the appropriate time to file to terminate father's parental rights. In doing so, appellants effectively called upon the Orphans Court to serve as a quasi-appellate and/or superseding court to the family court. Appellants assert that they have complied with the Adoption Act and therefore are entitled to the relief they seek. We fervently disagree that they have complied with the Adoption Act, as they have not proposed a valid adoption. This court has articulated that the purpose of adoption is creation of a new parent-child relationship. The testimony of appellants, whose credibility the trial court endorsed, confirms that the proposed adoption by appellants will not create any new parent-child relationship. The testimony was unequivocal that mother's role as mother and grandparents' role as grandparents will remain unchanged regardless of the outcome of the termination or adoption. The intention of appellants is not to create anything, rather is to preserve the status quo, their version of the status quo, that is, which notably includes the continued elimination of father from the child's life. This court has consistently rejected previous attempts to utilize the Adoption Act to gain custodial advantage, and father requests that the court uphold those principles in finding in favor of him and upholding the decision of the Superior Court.
Ms. Christensen, it's Justice Todd. You spoke in terms of continued elimination of father from child's life. Father himself made himself absent from the child's life for 2.5 years. He wasn't prevented. He was in jail for part of the time. He was in treatment. He was living in transitional housing. And for whatever reason, he did not reach out to child. So I don't think it's quite fair to say that they were seeking to continue to eliminate him from her life.
I do think, Your Honor, that one thing that mother did testify was that it was mother who decided in the fall of 2016 that she was no longer going to permit visits. I do think that the evidence shows, while father was absent from the child's life, there was also nothing to demonstrate that mother was welcome to father being part of the child's life. In fact, when father tried to be part of the child's life by participating in custody proceedings, that was the time which mother went and with grandparents filed to terminate his parental rights.
But that was after 2.5 years of no effort whatsoever on father's part, unless I'm missing something.
I think that is an accurate summation.
Thank you.
Ms. Christensen, Chief Justice Baer, I'm going to elevate you to become a member of our court. You just raised $5 million and gotten 2 million votes. Judge Pellegrini wrote in that this is a statutory process. They met the elements. Mom and maternal grandparents met the elements of the statute. The court's not free to ignore that. I understand, we all understand what's so bothersome here. How do you write this? Is it your suggestion as an advocate for father that we find the statute's not met, or we concede the statute's met and argue public policy? How do you see a reasoned decision of the Supreme Court?
I think that one thing that I find interesting about Justice Pellegrini's dissent is that it's our position the same argument could be made in terms of custody, that custody is also a statutory remedy. Father filed for custody. Why would he then not be entitled to the relief he sought in custody? There is no law that says that the Adoption Act supersedes the Custody Act, that the Adoption Act is of greater importance than the Custody Act. And so I think that it is certainly a public policy, as this court has articulated, but I do think that it creates, if the appellants are to prevail, it creates a tension between the Custody Act and the Adoption Act, and also between the Orphans Court and the Custody Court. The parties were in custody litigation. The custody conciliator had made a recommendation for reunification. The appropriate remedy for mother would have been to continue with the custody process that we've already established. And instead, she turned to the Orphans Court, and in effect, the Orphans Court then essentially served as an appellate court to the custody court because mother was dissatisfied with the custody action.
So your suggestion would be that we write that if the case walks, talks, and smells like a custody case, you can't go to adoption.
I think that that's accurate. I don't envy your position.
Ms. Christensen, that's not accurate, however, if we find that the statutory requirements of the Adoption Act have been satisfied.
I'm sorry, Justice Todd, can you repeat the question?
Yes, Justice Baer had indicated that the custody proceedings were more appropriate than the termination proceedings. And I said that's not necessarily the case, is it? Where the parties have satisfied the statutory requirements of the Adoption Act.
I think that one of the issues here would be that it's our position that the appellants have not satisfied the statutory requirements of the Adoption Act because they failed to propose a valid adoption.
And your position on that is because they're not creating a new family unit?
Correct, because mother testified that her role in the child's life would remain the same regardless of the outcome of the trial. Maternal grandfather also testified that mother was going to continue to maintain her daily routines with the child even after termination and adoption.
Counsel, this is Justice Doherty. Are you conceding that the mother provided clear and convincing evidence of 2511 A and B?
No, Your Honor, I do not believe that we are conceding that.
Good. Okay. That's what you confused me with that answer there, because that is the crux of your case.
Anything else from any justice at all? Ms. Christensen, anything you want to say in summation?
No, Your Honor, I would respectfully submit that the majority of the Superior Court accurately summarized this case as an unrestrained custody case, which should return to family court where father filed his petition. And that would be the relief that we would seek today, is for the decision of the Superior Court to be affirmed and the decree terminating father's parental rights be vacated.
Thank you very much. We'll take the case under submission. It's a very interesting case. We'll take a 5-minute break while we change counsels, and we'll hear our last case for 8.
The next argument is the Commonwealth of Pennsylvania versus H.G.K, appeal of the Pennsylvania State Police. Representing the State Police is Mr. John J. Herman. Representing H.G.K is Mr. Anthony J. Tamburino. And representing the Commonwealth is Mr. Scott A. McCabe.
In this case, the Pennsylvania State Police challenged the Superior Court's order quashing their appeal from a denial of a motion to intervene and vacate proceedings where the defendant sought removal and was in fact ultimately removed from the Pennsylvania Sexual Offender Registry. The Superior Court concluded that the State Police's motion and appeal, which were filed after the court issued a final order removing defendants from the sex offending registry, were untimely, and alternatively that any interest that the State Police had regarding the defendant's inclusion on the sex offender registry was ministerial in nature. This court granted the State Police's appeal. The State Police assert that they have been standing by the legislature in section 9799.74 of Title 42 to appear, and they have a right to appear and contest any filing where a challenge to a sex offender registration requirement has been made. And because they have been conferred legislative standing, due process requires that they be provided notice of such challenges. As they were not notified of defendant's removal from the registry until after the final court order removing defendant, they assert that their right to challenge the removal should have been reinstated nunc pro tunc. Mr. Herman, you're arguing on behalf of the appellant. Please feel free to proceed.
Thank you, Your Honor. As you indicated, John Herman from the Governor's Office of General Counsel for the State Police. As always, it's an honor to be before this court. Your Honors, from the State Police perspective and our understanding, the question before the court today in many ways is fairly narrow. It's what does Section 42 PACS Section 9799.74 really mean? And in that particular regard, we believe that the language is clear, Your Honors. Even looking at it fundamentally, the heading of the statute in Section 0.74 is standing for Pennsylvania State Police. It's very clear from even that the legislature intended us to be able to be heard on questions involving sex offender registration. But more importantly, when one turns to the language of the statute itself, it provides that except for petitions filed under Section 9799.59, the Pennsylvania State Police shall have standing to appear and contest. And those words are we believe, are very clear. We can appear and argue against a filing in a court of this Commonwealth, which seeks to challenge in any way the obligation of an individual required to register with the State Police under this subchapter. And when you look at that, Your Honors, the language that's in there, we believe is very clear and it's very broad. They say that we can contest a filing in a court of this Commonwealth. And that language, a court of this Commonwealth, is not restricted. It doesn't say the civil division, the criminal division. It says a court of the Commonwealth. And it says which seeks to challenge in any way. I believe those words "in any way" are very important. They lay out that anytime something comes up that affects the registration, that affects any part of the registration, parallel similar section under 0.42, they use that language. And it's clear from that broad language, they intended us to be heard when the question involves sex offender registration. I think it's exceptionally telling, even in the fact that where it talks about except for petitions filed under Section 9799.59, I think even the exception itself is important. The legislature clearly knew that this was a very broad grant, and they were writing it very broadly. And when they did not intend us to be heard, and they did not intend for us to appear, they made that a clear exception. And for those reasons, Your Honor, we believe that this is a very clear statute. It's clear on its face. And some of the arguments made by opposing counsel, when Your Honors really look at them, we believe they don't hold up to close scrutiny. For example, they talk about that the word obligations appears elsewhere in other parts of subchapters H and I. And we think that's critical. We mentioned this in our reply brief, that there's a difference between the word obligation in the singular and the word obligations as a plural. Here they're talking about the obligation of an individual required to register. And when you read that, especially in context with "in any way," it's clear that they mean not only the registration requirement itself, but anything underlying that registration obligation. And, again, Your Honors, we therefore posit that this statute is very clear on its face, and that, in fact,
Counsel, Chief Justice Baer, your argument for standing is absolute and broad. How do you respond to the argument, which was in opposing counsel's brief, that under 97, 99, 59, A7, in this scenario, and I appreciate it's a different scenario, where somebody has been clean for 25 years and is seeking to be removed from the list, the legislature took pains to provide that after a court grants relief, the state police shall be notified in writing within 10 days so that the person can be removed. Certainly indicating that in that scenario, the legislature didn't contemplate you being an active participant in the process at which the merits process at which the person would be removed or not removed.
Your Honor, I think what's critical there is the fact that 25 years have passed. The reason I would understand us to have given standing was to ensure that, that the broad mandate under the law that there be a statewide registry is respected. And if an individual is trying to get off without ever having been on, or raise some challenge to the registration obligation, especially early on, I believe the presence of the state police helps protect them. Conversely, if someone has been on the registry for 25 years and they meet the requirements for removal, essentially, I think basically that section says they have to have been in compliance for those 25 years. At that point, I think the math, so to speak, is a little different. It makes sense that the legislature may have said, well, this individual has been compliant for 25 years, so the interest of the state police in maintaining the statewide registry of public safety is respected.
Yeah, but counsel, let me interrupt you. The math may be different, but the legal precept is simply not different. If the state police reads the statutory language is to give them standing for any procedure through which somebody's going to go on the registry, stay on the registry, implicitly come off the registry, then as a matter of equity, you can't say, well, there's an exception to our universal standing, which we assert if you've been good for 25 years. Legally, factually, I get it, but legally, it doesn't work.
When Your Honor says legally it doesn't work, I guess I would have to respectfully disagree, or maybe I'm misunderstanding the premise. But
maybe you misunderstand. My understanding of your argument is that anytime somebody is going to go onto the registry, or that anybody is on the registry, you assert that the legislature has given you standing. And then you're saying, well, but if they've been on the registry for 25 years and fully complied, the legislature built an exception in this one section. And I think that's a hard, logical bridge to cross. And that's what I'm asking you about.
I understand your point a little better now. I still believe it's rooted in that policy. I don't want to be repetitive, but I think it's rooted in that policy of ensuring that individuals on the registry to protect the public safety. And I think that's different after 25 years have elapsed. But even to Your Honor's point, if to the extent that perhaps in somebody that creates an ambiguity, I think that's where maybe we start. If Your Honors don't look at the statute as being clear, or they believe that like creates some type of ambiguity, I would suggest that then looking at the legislative intent and looking at the policy behind the law would suggest that we were intended to be here, that we were intended to have standing except where noted. And first off, I would note that in the remarks, this is in our reply brief, there are specific citations, but there's not a lot of legislative history on this law. But if one looks to the remarks of Senator, I believe it's Valakovich, he talks about the concern about the removal of, I believe it was about 15,000 offenders if the law is not amended following the court's decision in the news. And similarly, Representative Marshall at one point, when offering an amendment to one of the acts, there was Act 10, and later it was reenacted shortly thereafter as Act 29. He talks about the need to offer an amendment to make sure that more than 2,000 offenders are not removed. I believe that was a concern brought to him by the state police, if I remember the remarks correctly. And my point being that it's clear that the legislature was concerned about individuals coming off the registry.
Well, counsel, let me ask you about that. Let me ask you, counsel, about that. I'm sure the legislator, as a body and as individuals, had all manner of concerns, and I'm sure that Representative Jones might have said X and Senator Smith might have said Y. Regardless of all of that conversation that goes on under the Capitol domes, we have to look what's in the statute. Given what you're saying about what the legislature intended or must have intended, why don't you just get them to write a notice provision rather than asking us to judicially conjure it? I mean, this might be totally unfair to the state police, totally unfair and illogical. But why is it our job to fill in the gaps when you right across the street there have something called the legislature?
Your Honor is referring to, even if I understand Your Honor correctly, you'd be referring to the fact that there's no clear notice provision included in that language. And Your Honor, I guess I would concede at some level that it would be preferable for it to be more clear, but I think the two things are somewhat clear. Excuse me. I think the two things are somewhat they're companions to each other in a sense. If you're given standing means little if you're not given notice. And I don't think the mere fact that they didn't put it expressly. I think there's a clear parallel to this in the Uniform Firearms Act. If one looks at the mental health provisions, 6105F and 6111.1G2, it basically just says that the Court of Common Pleas can hold a relief here. I'm painting with a very broad brush, but there's no clear notice provisions. It's not even necessarily clear from those provisions alone who has standing to appear and contest those petitions. And the Superior Court in re expungements basically did decide, as I understand it, that the state police had standing, and that as I read the case, as a corollary of that, we had to be given notice. And I think that's all we're suggesting here, Your Honor, is that because we've been given standing, notice naturally follows.
Mr. Herman, speaking for myself, I tend to agree with your position that this section 9799.74 gives the state police standing as a general matter, but the statute doesn't make you an indispensable party to these proceedings. And from my point of view, again, indispensable party status depends on the party's rights being so connected with the claims of the litigants that no decree can be made without impairing those rights. So really, I'm asking you, by what authority do you claim that you're an indispensable party to this litigation?
I would understand it, of course. I will, of course, respond to Your Honor's question. I didn't understand the question of indispensability to necessarily be before the court, and I say that very respectfully in the sense that
maybe I'm posing the wrong question, but it seems to me it's inextricably bound up. You may have standing, but for the purposes of this litigation in which you participate, I don't think you're on this record an indispensable party, that a decree could issue without any rights or obligations of the state police being impaired.
I believe, to the extent this court considers indispensability, I would respectfully suggest that we are, in fact, an indispensable party. If you look at our reply brief, we talk about the question of indispensability in one of the footnotes, and I certainly recognize that those two things, as you suggest, I think can be bound up together. And in this particular case, I would first note that I believe you can find we have standing and not necessarily find us to be indispensable. I think that is true as a matter of law. I think I have to concede that. But to the extent this, Your Honor, and this panel would believe that those two questions have to be answered at the same time, I believe that we are indispensable anytime someone's going to come off the registry. And I think that, if you look at the case law before this court's decision in Moniz, the personal way I've described it is it's somewhat erratic or confused, meaning in the sense it's hard to reconcile all the cases that exist. But in the case of Commonwealth,
you denied intervention, weren't you? You were denied intervention.
And then denied intervention, yes, in the Cheeseboro case, and there. I
No, in
believe
this
there may-
case,
Oh, yes, we were denied
thought
intervention
the
by
intervention was denied. So you'd have to show that you're indispensable to get into the case. The case can't be adjudicated without you before the court. That's what I'm probing. Just because you have standing doesn't mean you're an indispensable party.
this particular case, Your Honor, then I believe we are indispensable, and I'll get right to the point without delaying further. Not my intent, of course. The question of indispensability, as you point up, is whether, in essence, whether our rights are so bound up in this litigation that they can't proceed without us. And in this particular case, Your Honor, as with any other case, I believe the legislature gave us this standing so that we could be heard. If you look at the Demora case, which is 149 Atlantic 3rd 330, they talk about how in that particular case, the state police were indispensable because our priorities as the agency enforcing SORNA, the agency enforcing the sex offender registration, may be different than those of the district attorney. And for that reason, I believe we are indispensable. If you look at some of the prior case law, for example, In Re JB, which was also originally started out of York County, I believe, there was a decision ultimately by this court that juveniles who had been adjudicated delinquent could not be registered. At that point, the state police were not heard from, and that ended up being a case of statewide impact. It necessitated the removal of, I don't know offhand, but dozens, if not hundreds of individuals would be my understanding.
What about this case? And then I'm done. Tell me about this case, because this is the only case I particularly care about. How are the state police rights so connected with the claims of the litigants that no decree can be made without impairing those rights? That's the case law of this court. That's the only question I have, and then I'll finish.
Our right, my point in raising JB, Your Honor, was to say that our rights.
JB, this case. Claims of the state police. How are they so connected with the claims of the litigants that no decree can be fashioned without impairing the rights of your client?
The right of my client would be to enforce the sex offender registration laws. And any case which has the potential to impair our ability to enforce those laws, we are indispensable to. And anytime a case like this may have broader implications than just this individual. And anytime that happens, if it could impact the overall enforcement of the registry, our rights are so impacted that we must be heard, Your Honor. And I believe the more is that.
Does that mean, if I could follow up on Justice Saylor's question, does that mean, counsel, that in any kind of case, are we just sort of supposed to survey the ground and say it would be unfair that party X or party Y out there doesn't get notice? So even though the legislature didn't write that into the statute, and even though that the litigant has not developed a Goldberg versus Kelly due process type argument, we should just manufacture that notice requirement without more. I don't see how that's rooted to a legal argument or basis.
I would submit that those two things, as I indicated, are basically they are one does not follow without the other. And when you, like I said, when you look at the Uniform Firearms Act, for example, and I won't make the same argument again. My underlying point is simply that to be given standing, I think also implies that one would be given those. I think those two things, one without the other, is meaningless. Notice wouldn't mean anything if one didn't have standing to be heard, and conversely, standing means little if you don't receive notice.
Well, Mr. Herman, beyond that, anyhow, you found out about this thing and you tried to intervene, and the intervention was denied. Correct?
Yes, procedurally, yes, that's correct.
I mean, thank you.
Now, too, I believe it's important.
My computer doesn't. I apologize. I thought I had unmuted my computer and it didn't work. I perceive there's no further questions for you. Is there anything you want to say in summation?
I would just note that I believe that the case of Housing Authority versus Chester County is very important here. The legislature may confer standing. We believe it's clear both from a statutory construction as well as a policy standpoint that the state police were meant to be heard on these issues and to protect the interests of the Commonwealth statewide. That may not be as readily apparent to a district attorney who is only dealing with a criminal prosecution. And I would also note, Your Honor, in closing, this last thing I'll say, I think it's important to understand, Your Honor, this is a civil remedy now, as we understand it, following this court's decision in Lacombe and the current case law. This is a civil remedy that's administered by the state police, and it's no different than the Firearms Act. And just as we have the ability to appear and argue thereunder, we believe we have the same rights here as conferred by the legislature. Thank you.
Thank you very much. Mr. Tamburino, Mr. McCabe, you're both arguing for appellee. Whoever wants to go first, feel free. Please do not repeat each other.
Thank you, Your Honor. Anthony Tamburino. May it please the court. I represent the appellee, H.G.K. I'm with the York County Office of Conflict Counsel. Just briefly to note, Your Honor, I will be doing, I think, the majority of the argument for this. I believe Attorney McCabe has a few things to say in regards to the DA's position in this specifically in regards to notice. With that said, I would say that when you look at the plain language of the statute and read all of its provisions, PSP standing is much more limited than what it claims. Reading the statute plainly, PSP has standing to be heard in any type of proceeding that it involves an individual required to register. And if the individual is not required to register, then PSP lacks standing and it should not be heard. The focus here should really be on the word required, as PSP standing is only vested in challenges to the terms and conditions imposed for those already required to register. And I would say that if the legislature had wanted to broaden PSP standing to the degree PSP claims, it would have said that PSP has standing when an individual seeks to challenge in any way the obligation of an individual to register, rather than required to register. PSP's argument applying the phrase in any way to the substantive scope of their standing doesn't work given the position the legislature chose to put it in the statute. In any way follows challenges, not an individual required to register. And that makes it procedural in nature. This makes sense from our view because this court's recent pronouncement in Lacombe said that PCRA is not the sole remedy method of litigating sex offender registration. The quote filing can be PCRA, can be habeas corpus, declaratory relief, any number of different procedural mechanisms that this court and our lower courts, frankly, have seen over the years as far as contesting sex offender registration. PSP further in its reply brief has, in our view, overly complicated our argument by claiming we've removed the phrase in any way from the statute and we've changed obligation to obligations in the plural form in order to limit PSP standing in a way that does not include the application of SORNA, only administrative aspects of SORNA. But when you look at the statute plainly, we've removed or changed nothing. We've simply applied the statute to individuals required to register, which is what it says. The legislature intended PSP standing to apply to those cases, to those individuals required to register. And that is the dividing line the legislature set. And it takes into account PSP's predominantly ministerial function. If the legislature intended something different as far as their standing, they could have simply removed the word required, but they put it in there and they put it in there for a reason. This interpretation, in our view, fits, it makes sense, and it's a simple answer consistent with longstanding case law that PSP's function as far as sex offender registration is generally ministerial in nature. So in our view, failure to notify PSP can rarely, if ever, divest a court of jurisdiction because the legislature has not granted PSP any adjudicatory powers. PSP's responsibilities under SORNA include creating, maintaining, and administering the registry. The legislature has placed the duties to register on individuals with certain convictions, and while PSP can think a person is subject to registration, it can't register them sua sponte. It can refer a person who fails to register, of course, for prosecution, but that's by the district attorney. It can't make the adjudicatory finding itself. So under those circumstances, we believe the court should find that PSP standing is limited to those individuals required to register under SORNA and affirm the Superior Court's decision to quash this appeal. That's all I have, Your Honor.
Thank you very much. Any questions at all? Good enough. Mr. McCabe.
Thank you. May it please the court, my name is Scott McCabe. I'm appearing on behalf of the York County District Attorney's Office. In this case, the PSP is asking this court to grant it what the legislature would not, and that's specifically notice requirements. And as the Chief Justice recognized, the legislature knew how to do this in other parts of Act 10 and Act 29. So the issue for the Commonwealth is not, does PSP have an standing if they're in the courtroom to be heard on this? It's the question of who is supposed to give notice. And if notice is not provided to PSP, what is the effect of that? What is the remedy for PSP? Because certainly the Commonwealth and defendants have an interest in finality of the decision. If PSP says, I need to be notified every time, well, we have 67 counties in this Commonwealth. And as the Lacombe decision stated, the SORNA challenges can be made both at sentencing, post-sentence motion, direct appeal, PCRA appeal, habeas, quorum nobis, petition to enforce plea agreements, whatever. So who is supposed to give that notice? The legislature knows how to do that, and they did not grant the PSP notice provisions in here. What we would suggest is that the state police go back to the legislature and clarify this. Who is supposed to give the notice, and what is the remedy if they do not get notice in every single one of these post-sentence, direct appeal, PCRA, whatever, across 67 counties, all of these hearings?
Could I ask you a question on that, counsel?
Yes.
Pardon me. Question on that. Suppose that surprisingly the General Assembly does not react and actually do something about this problem. Hard to imagine, but let's just hypothesize that. In that situation, how do you propose that the state police are going to find out about these hearings? And connected to that, given that this is a non-punitive statutory scheme that's managed by someone other than the DA's office, in other words, is managed by the state police, does it really fall within the Commonwealth's exclusive prerogative, the DA's office, or is that a bit misplaced given the posture of these kind of registrations?
If I understand your question correctly, Justice Wecht, well, the Commonwealth doesn't have the exclusive. I mean, certainly PSP is there. I mean, that's the problem, is that there's just nothing there. There's been legislation passed in the past few years which puts certain notice requirements upon the court. Those notice requirements really fall upon the Commonwealth to ensure that they're followed through with, because if the court does not follow through with those notice requirements, it's the conviction that could be unsound. So really, this is an issue that the legislature has to grapple with, and the legislature has to set everything out. What they have is sort of a half-cooked standing provision that for some reason was added into the second to last section of SORNA 2. It's unclear why, and if they want to use this vehicle, especially in this case where it's not even a good case for them, to say, we need to reopen all of these cases. We need to reopen all of these hearings where we didn't get notice. Well, who is supposed to provide notice? York County is a very busy county. We have lots and lots of SORNA challenges constantly. So are we supposed to wait in the courtroom until PSP shows up? Do we have to send certified mail to PSP with a return receipt? These are the questions that we have. Is the trial court going to wait for the PSP attorney to show up throughout 67 counties? And all of these both trial, post-trial, appeal, PCRA, what have you, hearings. That's the real question for us. It's unresolved. They really need to go back to the legislature instead of having the judiciary fill that hole, as the Chief Justice suggested earlier.
Mr. McCabe, Chief Justice Fair, as I was preparing this case, I was trying to envision how in the world this would work if the state police prevailed or the legislature reformed the statute and gave them standing. Would we have 3 tables in the courtroom, the state police being in the prosecutor's table, you moving over to the defense side under what's occurred in this case? I mean, the Commonwealth Attorneys Act say you act for the state, but under these cases, you would not be acting for the state. The state police would. As we can tell, they have somebody from the office of the governor arguing this.
I know sometimes in the firearm disability hearings, both the DA's office and PSP, they participate together, and the trial court allows both of them to participate on the same side, but recognizes that their interests are different and their legal arguments may be different. So in the courtroom, that doesn't seem to be a procedural bar. The DA's office would not be on the same side as the defendant, and the PSP would have, the trial court judge would give them a full opportunity to air whatever arguments they wanted to air. But how do they get there? See, is it going to be my responsibility to notify someone in PSP General Counsel's office every time we have a hearing? And how do I do that? How do I inform the court? What happens if they don't show up? What happens if they need a continuance? It's not like this is an occasional hearing.
It's the kind of complex procedural scheme that would fall to the legislature or to an executive branch body under regulation. And your argument is the judiciary is poorly suited to try to articulate that scheme.
Especially in a brand new statute where they had the opportunity to do this, they know how to do this, and they chose not to do it. So what's not in there is important, not some random remarks on the House floor.
All right, thank you. Questions from anyone? All right, counsel, thank you so much. We will conclude our April argument. We'll take a 5-minute break and the court will convene alone to consider the cases preliminarily.
Thank you, Your Honor.